Hello, everybody, and welcome to History Bite number 104, dated November 7th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled The Original Jurisdiction of the U.S. Supreme Court. Many Americans are unaware that our nation's highest court, the Supreme Court, possesses original jurisdiction in addition to its appellate jurisdiction, which is, of course, very well known. Remembering the two types of jurisdiction and what exactly they require. Original jurisdiction allows one to originate or begin a case at a particular court, all right? Appellate jurisdiction requires a case to have already been adjudicated in a lower court or administrative body first before coming to that court, all right? The Supreme Court possesses both, okay? Which means that the Supreme Court can hear cases in their first instance. You may originate certain types of cases there, as well as have cases appealed there, okay? The vast majority of the court's jurisdiction is, of course, appellate. But in a very select class of cases, one may originate a case at the U.S. Supreme Court under its original jurisdiction, although it is, like I said, very rarely utilized. Okay, remembering the scope of federal judicial power, we go back to Article 3, Section 2, Clause 1 of the U.S. Constitution, which reads as follows. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, other public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states. The rest of this clause was modified by the 11th Amendment, which we will cover in a separate history bite. Moving down to Clause 2 of Section 2, it reads, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. End of story. These are the types of cases which the U.S. Supreme Court may hear, if it chooses, under its original jurisdiction. I'll read it once more. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In other words, you may initiate these types of cases at the U.S. Supreme Court, okay? This is the extent of the court's original jurisdiction. Nothing more, nothing less. Clause 2 continues on to say that in all the other cases before mentioned, that's everything in Clause 1 that we just read, okay, the Supreme Court shall have appellate jurisdiction, which means cases involving those particular issues and under those circumstances had to have been heard in another court or administrative body first, okay? The Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So the Constitution in Clause 2 of Section 2 of Article 3, okay, discusses the Supreme Court's original and appellate judicial power and gives Congress regulatory power specifically over its appellate jurisdiction. And that has been also interpreted to allow it certain type of regulatory power with respect to its original jurisdiction, which we will go to now. In Volume 28 of the United States Code, Section 1251, titled Original Jurisdiction, the Congress has set out regulatory provisions with respect to the enumerated original jurisdiction of the United States Supreme Court. It reads as follows, okay? Again, this is Volume 28 of the U.S. Code, Section 1251, entitled Original Jurisdiction. A. The Supreme Court shall have original and exclusive jurisdiction of all controversies between two or more states. All right. This is the only exclusive original jurisdiction that the Supreme Court has when it comes to controversies between two or more states. All right. This, in other words, what that means is only the Supreme Court may hear this type of case. All right. Exclusive original jurisdiction to the exclusion of all other courts. Only the Supreme Court may hear this type of case. And those are controversies between two or more states. Okay. B, the Supreme Court shall have original but not exclusive jurisdiction of, number one, all actions or proceedings to which ambassadors, other public ministers, consuls, or vice consuls of foreign states are parties. Okay. 2, all controversies between the United States and a state. And 3, all actions or proceedings by a state against the citizens of another state or against aliens. Okay? So the Supreme Court has the original jurisdiction to hear those other cases in Section B, of course, but not exclusive jurisdiction. Okay? Their original jurisdiction is already laid out in the Constitution. Okay? They can hear those other types of cases in B, but that jurisdiction is not exclusive, okay? That means that the authority to hear those other types of cases surrounding its original jurisdiction in Section B, okay, can be heard by other courts, okay? So the Supreme Court, obviously, is not the venue in which the vast majority of those cases will be heard, given that Congress has not made the Supreme Court's jurisdiction exclusive in those cases. It has only made it exclusive in cases between two or more states, okay? Of all controversies, in fact, between two or more states. That is the only time in which the Supreme Court's original jurisdiction is exclusive in a particular type of case, okay? When there is a controversy between two or more states, okay? That must be heard by the Supreme Court. No other court in America can hear that type of case, all right? Now, of course, as I stated above, the original jurisdiction of the Supreme Court is rarely utilized, and it has never constituted more than 2 to 3% of the court's total docket at any given time, okay? Between 1789 in 1959, the court issued roughly only about 123 opinions in original jurisdiction cases. So that's 170 years, okay? And it only issued 123 opinions in original jurisdiction cases. Not a whole heck of a lot, folks, all right? So we see that 97% of the court's jurisdiction essentially is appellate, okay? That is the primary function and role of the U.S. Supreme Court under its appellate jurisdiction, to have and give the final say on the meaning of the Constitution and laws of the United States, all right? It's original, and of course those cases are on appeal, okay? The original jurisdiction docket has always been small and will likely always be small, okay? Since 1960, there have only been roughly between 140 and 150 motions for leave to file original jurisdiction cases in the U.S. Supreme Court, and most of those are denied, okay? As it has become, all right, most of the cases, as we are going back to remembering, disputes between two or more states, okay? Most of the cases are involving land disputes between the states, okay, which is why most of the cases are denied, all right? Supreme Court typically will only take those type of cases, even though it has exclusive jurisdiction over them, if those cases present some sort of significant statutory or constitutional question, all right? And let's face it, who controls this river typically doesn't present that type of question, all right? But that does not mean that it won't get granted, and occasionally it does, all right? A notable one affecting my home state here in Maryland was heard by the court, case of Virginia versus Maryland in 2003, okay? So, like I said, with that, the vast majority of original jurisdiction motions are denied by the Supreme Court. They will not be heard. And that's largely, like I said, because the court has, frankly, more important things to deal with than states bickering between one another over, who has access to this particular river, who has, who owns this mountain, things like that. Literally, I'm not being facetious here. This is the type of stuff that these disputes between the states typically entail. All right. We learned, all right, from the case of Marbury versus Madison that given that the Supreme Court's original jurisdiction is set in stone here in the Constitution, that Congress cannot alter it by statute. It cannot increase the amount of cases heard by the court under its original jurisdiction. All right. And by the same token, it can't reduce it either. And it was in dispute for about a good 80 years after Marbury versus Madison, whether or not the court had any power, whether Congress had any regulatory power over the court's original jurisdiction. And it was not until 1888, some 85 years after Marbury versus Madison, where the court ruled in Ames versus Kansas, that, essentially, if Congress had delegated some of the court's original jurisdiction authority to be heard in other courts, that was perfectly permissible under the Constitution, all right? As long as the avenue is still open to the Supreme Court, all right, it's okay, all right? But, the avenue could not be closed to the Supreme Court, all right? So that's known, of course, as concurrent jurisdiction, when more than one court has the authority to hear a particular type of case, So that's pretty much the original jurisdiction of the United States Supreme Court. Again, very rarely utilized, only constitutes about 2 to 3% of the court's docket. It's always been a very small part of the court's docket. And historically, with emphasis on the section reading cases in which a state shall be a party, most of the cases heard throughout the court's time under its original jurisdiction have been active legal disputes between 2 or more states. So that's original jurisdiction in a nutshell. I'll read it one more time. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. That's the court's original jurisdiction, folks. And that about wraps this up. If you have any questions or controversies, please leave them down below. I'll be happy to answer them, And if you have not subscribed to my YouTube channel, I would be most humbled and thankful if you did. Take care, stay safe out there, and I'll talk to you at the next History Bite. Peace.